YouTube, it's Tone back with another one for you. This one is a continuation of dealing with presentments. This is the fifth video. Awesome book. I think you're gonna like it. And here we're gonna get into a few more topics. So let's get into this shit. So in 1933, this is coming off the last chapter that we just did and all that. And so anyway, in 1933, U.S. Incorporated declared bankruptcy as publicly noticed by House Joint Resolution 192 of June 5th, 1933, also known as Public Law 73-10, Perry versus U.S. 1935. So the result is that there is no money, i.e. no real money, which is substance, such as gold and silver coin, that pays debts and is the coin of sovereigns. It's crazy too, because I mean, I think I don't know. We'll get into the gold and silver thing at some point in the future. So, because I got some interest. I mean, I think I have an interesting take on the whole precious metals thing in general. So there is now only the representation of the symbol of money, consisting of debt created against credit, appropriate for bankrupt citizens devoid of capacity. The credit used to create and back the debt currency is provided by us through having given our gold in the 1930s and our labor ever since to back the failed corporation. Among many significant consequences of this are that there are now only bills of exchange, notes, and other evidences of debt to circulate as money. All currency today is created by the signature. So, and all money is debt money. We operate off fiat currency. So when you create debt, essentially what you do is create money, and then you can collect the credits on the private side. There's always two sides to the books, public and private. So assets, liabilities, things like that. So when we accept and return a presentment for value, we discharge an obligation and render the offerer devoid of claim. This banker's acceptance, BA, utilizes our standing in law as the creditor, the source of the credit, to discharge the obligation by using our exemption for offset and adjustment. We become established as creditor and owner of both sides of the transaction. In the past, we have usually sent the presentment back to the issuer ourselves. Now we realize that it is far superior to use a notary to send it to them. The notary does not care what is on the presentment of our paperwork or the amount involved, i.e. whether a document says $1 or 10 billion. And that was interesting too, because when I was bringing all my stuff, and so I was just using the city hall notary over there, so you get the state stamp and all that. And when I was doing all my paperwork initially for the UCC1, I was curious if anybody else had ever done that there. And I'm like, you guys ever seen any of this? And she's like, no. So, I mean, so when they say that like it's 1 in a million that will figure this shit out, it literally is that. So you see, and that, there's even people who are slightly on the tail of this information, but for like the most part, the people that actually take action, I think are, I mean, they're getting higher now. You know what I mean? But things like that. Like, so when I asked the notary at the city hall if anybody else had ever done that there, and she said no. That's pretty telling in a city the size of that. You know what I mean? So anyway, the only thing that the notary cares about is whether the document has a place for endorsement and a jurat. A jurat is when you testify under the penalty. That's what a jurat notary is. So thereby justifying taking your fee, putting your document in an envelope and serving it on the other party, saying respond in 10 days. This time period is in accordance with Regulation Z, Federal Truth in Lending Act, 15 U.S.C. 1601, consisting of 3 days for mailing, 3 days of acceptance and return for value, then 3 days for return in the mail, plus 1 day for the day of service, which does not count on the time clock. The total time is therefore 10 days. And so that's what people usually put on their documentation. You can make up whatever number you want, but 10 days is good enough, I think, to let them fucking decide if they're going to argue with you or not, So when we have the notary serve our acceptance and return of the presentment to the offerer, the notary's address is given for the respondent to send the check, the remedy, or the reply to. When a respondent does not reply to the notary within the required 10 days with a notice of discharge of the obligation, he is in dishonor of our acceptance for value. He has not adjusted the account and is keeping the account open and the charge in place, continuing to cause trouble for us and make money by stealing our exemption. When no response from the original presenter is received by the notary within the required 10 days, we have the notary issue a certificate of non-response, which is a certificate of dishonor. At this point, the dishonor of the issuer of the presentment is established on the commercial record. A notary's logbook is an irrefutable substantiation of facts and admissible as evidence in any court. The key to the notarial process is that a certificate of non-response issued by a notary is a judgment in estoppel. The first certificate is a non-response, is a judgment in estoppel on the law. The second judgment is estoppel is on the facts, money. Ideally, we should do both when dealing with a presentment, since we wish not only to discharge the obligation, but to use the process to better us commercially. We must remember who and what a notary is. Historically, the notary wrote the king's papers. He issued the writs. A public notary is higher than a judge. In addition, notaries have had from inception two primary functions: to protest international bills of exchange, and to be a bonded neutral party who holds the commercial record and can place evidence into in court of any jurisdiction. Thus, the notary, as the ultimate holder in the commercial record, is higher than any judge, inasmuch no judge can act without the record. So there it is. So the great value to us is that through the notary we can place unimpeachable evidence into a court case for the record. And so that's why it's good to always have them get that done, and then you have your witness there as well. So when I go to the post office too, I'm doing my 3665 form. That counts as delivered. So it doesn't matter what the hell you sent. The fact that the postmaster stamped that as delivered, received, saying that you received it, there's no way that you could ever say that you didn't receive that, because you got your witness there, you got the postmaster stamp. You're in a whole different jurisdiction at that point. You're in the Universal Postal Union at that point. These people don't really have nothing to say. And they really never did. We just assumed that what they were saying was actually valuable and meant something. Crazy, huh? The commercial tribunals, courts of the U.S. and the states are in the private equity admiralty jurisdiction of the alleged creditors in bankruptcy, the IMF. So that's who's bankrupt, and they're the ones holding all the bonds and shit that are payable to the bearer on demand, by the way, to the IMF. International Bank of Settlements and shit like that. So two, as admiralty courts, the tribunal deals in matters of contract in which we, the defendant, is presumed to have contracted on land to be on the ship, where the captain's word is law. One is presumed guilty unless proven innocent, and the burden of proof is on the defendant to prove that he is not guilty, i.e. prove a negative. And how do you prove a negative? You don't. How can you prove that you're not a danger? How the fuck would you like me to prove that I'm not a danger? How would you prove that you're not one? You know what I'm saying? Like, come on. The shit's fucking ridiculous, to be honest with you. So three, as equity courts, the ultimate arbiter of a matter is the conscience of the court, which is how the judge happens to feel that day, and is not anything accessible by the defendant. There is no conclusions of law and findings of fact issued, since it is in equity, not law. Nor are there any facts. Nor does any documentary material evidence exist established on the record of a case. Attorney, as we have discussed, cannot be a competent witness. So four, since these commercial tribunals function in a private admiralty equity jurisdiction that does not have any capacity to access law, it cannot deal in facts, in reality. It must deal on color of those things, i.e. assumptions, color of facts. The assumptions become facts when both parties agree and stipulate that they are true. And that's all going to be contracts, agreements, and those are going to be facts. Agreements are going to be facts because facts don't really exist in law. Subjective. So contracts are king. So you cannot invalidate one's assumption with another assumption. You can invalidate an assumption only by placing facts and evidence on the record. Number six, anyone in dishonor in any legal proceeding has forfeited his capacity to state a claim upon which relief can be granted, and must legally, commercially lose if the other side remains in honor and proceeds correctly. Seven, if both sides of a dispute are in honor, which is normally the case, since all attorneys argue and dispute as do most pro se litigants, so they're pretty much on the same plane at that point, because they're both there arguing. They're both in combat, commercial combat. So whoever is ruled as the winner is a function of the judge's discretion, concerning which he has a carte blanche to proceed as he wishes, because you're giving him the authority to rule on the case, because you two people are sitting there arguing because there was no contracts, obviously. If there was contracts in place, there would already be agreed upon stipulations, which would eliminate the need to have a referee for any of those situations, wouldn't it? So if we can enter documentary material evidence as facts on the record and require the judge to take judicial notice of that evidence, we have a platform from which we can win, because without stipulations, the other side has no evidence, facts to support their claim. 9, as a result of the above, it is logical to conclude that not only must we place our evidence into the court in any case which we are involved, have the judge judicially notice it and act on it in the way that provides us a win, but placing evidence on the record and causing its existence to ensure that we prevail in this is the only reason we should ever go to court, to ever deal with a court. And that's the thing too. So, I mean, if you don't have to go there, then don't. But if you're going to go there, drop the fucking hammer on them and make sure that you already won the case via mail, because that is the court. Make sure that there's already a freaking agreement via court, whether it's their sign and acquiescence or whatever it may be, and you bring that in just to go over the facts. So we must, the facts. So we must act from the beginning and ever, as always, from the purpose of setting out evidence on the record in any case in which we might have to be involved, so that we can not only win, but if we act correctly, make money, perhaps a considerable amount from the situation. And that's why it's good to always have your contracts in place with your fee schedule and things like that already set, already agreed to at that, not even already set, but already agreed to by these people through their silent acquiescence. So when you start sending them invoices, they're not going to have a stupid ass look on their face because they already agreed to it. So the next logical question is, how can we place evidence on the record in a case? The following means may be deployed for entering evidence on the record. Number 1 is a deposition, testimony in open court. 3, affidavit, not as good as the first 2 unless one can cross-examine the affiant or the witness on the stand. Number 4, entry of evidence into the record by a notary. Of all the above cited methods for entering evidence into a case, the 4th method, the notarial process, may be the most desirable. By doing so, one may enter the evidence one so chooses by a means that must be admitted as evidence on the record, which no court can refuse to enter, and do so preferably without having to endure the time, effort, and expense of depositions and attending court proceedings. Now, that's a really good point right there, too, to just use a notary instead of sitting there arguing with the clerk. You know what I'm saying? So we must always remember the following. Number 1, stay in honor and never dishonor anything or anyone, including policemen, officials, judges, and even attorneys. Your opponents must go into dishonor on their own volition, on their own will. So number 2, put the issuer of a presentment into a position of having to put up or shut up, i.e. place the burden of proof on him. Conditional acceptance upon proof of claim, right? Number 3, establish all documents substantiating our claims on the record for the notary and the evidentiary record of any court case involved with the transaction. Number 4, relate properly with everyone involved, especially the court and judge, so that you can make the best use of your situation, i.e. prevail and also make money. Number 5, do not talk for any reason that does not serve your interest, and be prepared as much as possible to know what you wish to accomplish, what not to allow to happen, and the proper way to say what can succeed in achieving the results that you desire. They must have your words, your admissions, and even your legal determinations to hang you. Number 6, never make an offer, a supplicant dependent position. So, because when you receive one of these offers from them, you can change it, you can counter offer and things like that. I will counter offer, and it's coming with an invoice, you know what I'm saying? So being acceptor instead, the power is in acceptance, and without acceptance, we cannot win. Conditional acceptance is cool. I mean, it's considered a traverse, which is kind of a challenge, but it's an honorable challenge. So you can do it and still not really end up in dishonor. Conditional acceptance is still an acceptance under the conditions and stipulations therein, right? So you do have options there. You just gotta learn how to play the game properly, and staying in honor ultimately is gonna be the key. Because these people are grimy and they're going to slip for sure. So the tangible steps, processes, documents involved in dealing with any presentment consist of several phases. Number 1, execution, filing, and notice of foundational documents stating rights, standing, and capacity. Number 2, administrative actions concerning a presentment, both pre-court and non-court. 3, documents and dialogue in court. Number 4, if the issue is a mortgage, securing both legal and equitable title to the property, as well as the right of possession must all be done. Collecting on the money. Collecting from dishonoring persons can and has been done, but a discussion of the process is beyond the scope of this article. It is enough at this point to master the essentials, execute necessary paperwork, and remain free of debt and incarceration. In the event they ignore everything we do, we can proceed to collect from them by a number of possible means, including non-judicial strict foreclosure, as outlined in Chapter 9 of the UCC. We can also instigate a bankruptcy proceeding in which we are the debtor in possession and thereby able to accept and reject all offers. They are delinquent creditors, and we can request that an offset be performed that results in our collecting against their bonds, equity, or risk management department. Risk management department. The risk management department. You guys should look into that, because you're going to need that when you want to start putting liens on these people and things like that. So you're going to find all their bond information and things like that. So part 3, civil and criminal charges. Whenever you receive a traffic ticket, citation, summons, complaint, indictment, etc., what you receive is a public offer. It is an offer of indebtedness to your strawman. It is a conclusive presumption, i.e. fact, that your strawman is obligated to provide the funds if you act in dishonor. In commerce, the penalty for being in dishonor is losing one's equity. Remember that no courtroom in this system, since they are all in the public realm, can see, address, or deal with the real you. Public courts can only deal with assumptions and fictions in their colorable, phony system. As such, there are no facts other than what is stipulated or agreed to by the parties. If any adversary says the sky is green and you agree, the agreement constitutes a fact. The commercial tribunals of the system are all contract courts, and your stipulation is contractual ratification, which is the law of the matter. People lose in courts because they try to counter or neutralize one's assumption with another. If you are in dishonor, you will be forced to provide through your strawman public funds, Federal Reserve notes, or the equivalent, one way or another to satisfy the obligation. This can be by simply parting with Federal Reserve notes, doing community service, or by being incarcerated as the surety for the obligations of your strawman. In the latter case, they create the bond by further borrowing against your strawman. This generates funds that are used to balance the books and also make considerable additional money for the courts, judges, attorneys, etc. Given the immensity of the money made per CAFR and LAFR, which is several times the amount of the entire economy of the private sector, the mania of the United States for charging, prosecuting, and incarcerating is understandable, right? It's understandable if you're a fucking greedy piece of shit. Then that shit makes a lot of sense, all right? It's understandable if you're a greedy piece of shit. Let me put it like that. The following are important considerations in the equation. Number 1, as investors in the bankrupt corporation called the United States as well as the USA, the parent corporation, we, as real people, are the true creditors of the country and the source of the wealth, as discussed above. As such, we are exempt from taxation from the public side. The creditor and sovereign cannot be taxed by a system that functions by using the credit of the creditor. So how are you going to sit here and start taxing somebody when you're literally running off of their energy to begin with? You see the, you know what I mean? So the public side is debt, operating by borrowing against us, being derivative and dependent. The tail cannot wag the dog. The reflection cannot dominate the reality that it reflects. The system does not deal with us as real beings. It deals with a fiction, a symbol, which is not us, and therefore does not require the system to deal with us as the creditor and sovereign. Moreover, the public domain can tax and regulate only what is created in and belongs to the system, which can only be strawman and never real beings. Number 2, as creditors, sovereigns, and true owners, preferred stockholders of the country, we have authority to offset any obligation imposed on our strawman by the public side by making our exemption, which is unlimited, available to discharge the charges. The source from which the obligation was derived is our own credit, which can therefore be used as the asset to offset the obligation created by the borrowing against that credit. 3, the size of the purported obligation as well as its severity is technically irrelevant. That which can be invented in the form of an alleged obligation can be offset, i.e. discharged with the same ease as the obligation was created because it was all in your head to begin with. The whole shit. So all public debt is nothing but numbers, digits in the matrix. Promissory notes creating currency by signature got us into this mess. Promissory notes can get us out. So when they say that you're paying for all your sins, your sin is your signature. That's your sign. That's your signature. So that's what so be careful what you sign, because you're sinning. You know what I'm saying? And so you're going to have to deal with the consequences of that action. Keep that shit in mind. It is the game of chess. Stop playing checkers with these clowns. That's what I got for you for now. Until we meet again.